Welcome to The Explainer. We're jumping right into a huge Supreme Court case today, one that could totally change the game for gun rights for millions of people across the country. So, could firearm permits actually be abolished nationwide? That is the question here. The Supreme Court has taken on this emergency case, and it's all about these permit systems that a bunch of states put in place right after that big Bruen decision. You remember that one, right? The case that said gun laws have to line up with our country's history and tradition. Well, this new case is putting that whole idea to the test, and it's become a massive national debate. All right, first up, a Supreme Court surprise. And to really get what's at stake here, you have to understand just how, well, weird this is. It's a shocking move from the court, and here's why. So, for more than 2 years, ever since that Bruen decision, the Supreme Court had this very clear pattern. They denied every single emergency Second Amendment case that came their way. They just stayed out of it. Until now. That pattern, it just got shattered. And when I say rare, I mean really rare. Think about this. Usually, less than 1% of these emergency appeals get accepted while a case is still being fought in the lower courts. It basically never happens. So for the justices to jump in now, well, they must have seen something that they felt couldn't wait. And here's the bigger picture, the context for why they jumped in. Even after the Supreme Court laid down the law in Bruen, the lower courts have been upholding these restrictive gun laws a whopping 83% of the time. Legal experts are literally calling this massive resistance. You can see why the Supreme Court might feel like its authority is being ignored, and why they finally decided they had to step in. Okay, so now we get to the heart of it. A nation legally divided. What was the one thing that made this case the exception? Well, it all boils down to a massive, chaotic, legal mess that's splitting the country right down the middle. This is what's known as a circuit split. And honestly, this is one of the main reasons the Supreme Court even exists. It's their job to fix this kind of confusion. When you've got federal courts in different parts of the country looking at the same issue and coming to completely opposite conclusions, someone has to be the final referee. The Supreme Court has to step in and say, okay, here's the one rule for the whole country. And this slide just lays it out perfectly. Look at this. You have almost identical firearm permit laws, right? But if you're in the Ninth Circuit, say California, those laws are considered constitutional, but cross over into the Fifth Circuit, like Texas, and suddenly they're unconstitutional. Your constitutional rights literally change depending on what state you're in. That's the definition of legal chaos. And it's not just the courts. The states themselves are lining up on opposite sides. You've got a massive coalition of 26 states, we're talking over 175 million people, all arguing that these permits are unconstitutional. And on the other side, you have 17 states defending them. This is a fundamental disagreement about what the Second Amendment even means to. So we have the courts divided, the states divided, but then something happened that no one saw coming. We're moving on to the DOJ's unprecedented move. This is where the story gets really interesting. Get this. For the first time in decades, the Department of Justice, the DOJ, is arguing against a state's gun control laws. This is a total 180. And they're not just quietly submitting a document. They've asked to stand up and argue in front of the justices. That tells you the federal government sees this as a make-or-break moment for national policy. So what's their big argument? It's what they're calling an effective ban. They brought the receipts too. They showed the court that back in 2020, getting a permit took about 30 days. Now, it's often over 120 days, sometimes even a full year. The DOJ is saying, look, a delay that long isn't just a delay, it's a ban in disguise, especially for someone who's in immediate danger and needs to protect themselves now. But hold on, because the case gets even more charged. We're about to look at the controversial origins of these permits. And this part of the argument, well, it digs into some of the most difficult parts of American history. The argument being laid out for the justices is that if you trace these laws back, you find some really troubling roots. The claim is that modern permit systems are the direct descendants of laws that were created with explicitly discriminatory goals. We're talking about laws from the post-Reconstruction era designed to disarm Black Americans, and later laws like New York's Sullivan Act in 1911, which were aimed at keeping guns away from Italian and Irish immigrants. And here's the critical part. The lawyers arguing this say, look, these aren't some fringe conspiracy theories. They're pointing to established historical facts, cited in multiple legal briefs filed with the court. They're saying this isn't just a dark footnote in history. It was the entire point of the laws back then. The original intent, they argue, is right there in the historical record. And they're arguing that this isn't just ancient history. They've brought modern data to the court that shows even today these laws can have a disparate impact. In some of these states, Black applicants are denied permits at a rate that's 2.3 times higher than white applicants.
That, of course, raises some very serious questions about fairness and equality right now.
Okay, so that's the case. Now for the big question. What happens next? Let's talk about the reshaping of rights. If the court does strike down these permits, what does that actually mean for the rest of us? Well, for starters, look at this number, 110 million. That's how many Americans are estimated to live in states with these kinds of permit laws. If the Supreme Court rules against these systems, that means an immediate, overnight expansion of Second Amendment rights for every single one of those people. And it wouldn't just stop at permits. You have to think of it like dominoes. The legal reasoning the court uses could set off a chain reaction. It would create a brand new precedent to challenge all sorts of other state gun laws. Waiting periods, purchase limits, registration requirements, you name it. We could be looking at the dismantling of entire regulatory frameworks that states have built up over decades. That's why this is so huge. Legal experts are saying this could be the single most significant expansion of gun rights since the Second Amendment was actually written. With oral arguments scheduled for January 20th, a decision is coming, and it could literally redefine the relationship between citizens and the government. So, this brings us back to the ultimate question, one that this ruling will force all of us to think about. How will this ruling redefine a citizen's relationship with their constitutional rights? It doesn't matter where you stand on the issue, this decision is going to force a national conversation about that very question, and we're going to get an answer very soon.